Welcome and thank you for joining me for Tax Break. This is a podcast about South African tax for South African tax professionals and practitioners. My name is Pieter van der Zwan, and in each episode I share my thoughts with you on a topic or a recent development in South African tax. And I try to keep the episodes short enough that you can listen to them whenever you've got a few minutes to spare. In this episode, I'm looking at a case dealing with the income tax treatment of raising fees incurred by taxpayers. So in other words, the expense side where the borrower, in the context of a loan, incurs these raising fees. And the specific case that I'm looking at is a tax court case, so it may well still go on appeal. So it's something to look out for, and it's described as the taxpayer trust case. So remember, in the tax court, the judgment doesn't give the name of the actual taxpayer. It's only when it goes in, when the dispute is heard by the higher courts. Right, so the taxpayer in this case incurred raising fees relating to debts that it used for property development. Important, these raising fees were incurred after 2018, and you'll see why this is important just now. The raising fees were calculated as 2% of the loan capital. It was payable upfront before the loans were drawn down, and they were paid to an agent to arrange the loan. The taxpayer deducted the raising fees under Section 24J. So I think at this point we can perhaps just pause to briefly look at what Section 24J says. So Section 24J, remember, is a section that deals with the deductibility of interest. Specifically, or amongst others, the deductibility of interest. Specifically, Section 24J2 specifies that you can deduct interest on the basis set out in Section 24J if the interest is incurred for purposes of a taxpayer's trade and in the production of its income. There's no capital requirement there. Now, 24J then applies to interest, and interest is a term that's defined in Section 24J. Now, this definition is quite broad, but it includes interest or similar finance charges. So the taxpayer considered the raising fees to be similar finance charges, and on that basis deducted the raising fees under Section 24J. SARS argued that these raising fees were not similar finance charges, therefore they did not fall under Section 24J, and you had to consider their deductibility under Section 11A. And if you went back to 11A, that does have a requirement to consider whether the expenditure is of a capital nature, and SARS considered these expenses to be capital in nature. So as you can see, there's quite a big difference in the outcomes whether you apply 24J or 11A to these raising fees. Now, before we go to the judgment and the court's reasoning, I think there's a bit of context and history that one needs to understand. So back in 2011, there was a Supreme Court of Appeal case, the South African Custodial Services case, that considered a few things, which included the application of Section 11BA. Now, Section 11BA dealt with interest, including related finance charges. And the judge in that case concluded that a list of costs which included raising fees were related finance charges because of their closeness to obtaining the loans. At the time, Section 24J had similar wording in its definition of interest, so it also included related finance charges. And in a tax court case in 2022, the court reached the same conclusion as the custodial services case in the context of Section 24J. Important, this was in the context of 24J and raising fees before the amendment of Section 24J. So then in 2016, Section 24J was amended to no longer refer to related finance charges, but to similar finance charges. So in the taxpayer trust case, the court had to essentially determine whether the raising fees were then similar finance charges to interest. So that was really the crux of the question that the court had to consider. Now, in reaching its conclusion, the court looked at a few things. and I'd like to highlight a few of them perhaps. The first one is that the definition talks about interest or similar finance charges, and the judge said that the fact that there's an or between these terms suggests that we're looking at alternatives. So what we're looking at when we're looking at similar finance charges is something that is not interest. It's an alternative to interest. It's something else. The court also considered the dictionary definition and found that finance charges is defined widely enough to include raising fees. So the question of interpretation therefore really centered around whether these finance charges are similar to interest. What the court then did was it identified some case law where the term similar was described as having a resemblance in some relevant respects. And the judge's reasoning was in applying this was to say that are the resemblances that we can see between raising fees and interest, or then the differences between these two things, which of these resemblances or differences are relevant and what not. So Sarge argued that the raising fees to be similar must have all the fundamental characteristics of the common law interest meaning. So in other words, it must be for the use of money. But the judge then indicated that Sarge actually conflated the words same and similar. So the court considered whether the fact that the timing of the raising fee is different from interest, the fact that this was necessary to draw down the loan, whereas the loan is, once it's drawn down, the money is being used, the lack of reference to time value of money, and the fact that the payment was made to arrange the loan, not necessarily use the money, whether these are dissimilarities that could then cause the raising fee not to be similar. And then in respect of all of these things, the court found that they are not relevant dissimilarities. So what the court concluded was that despite all these differences, if it wasn't for the raising fee, there wouldn't be a loan. So this is part and parcel of the compensation for the loan. In this case, the court concluded that the raising fee was in fact a finance charge similar to interest on the basis of what it considered the relevant resemblances. Perhaps interesting to note is what the court did not consider, and that's the explanatory memorandum to the 2016 amendments, where the Treasury described the reason for replacing the word related with the word similar as to clarify the policy position that applies to finance charges of the same kind or nature. So I don't know if there's really much in it, and if it really adds much to the debate. But the word same here could maybe suggest that what the intention was to say that something should be the same as interest, although that's not what the wording says. In the law, it talks about similar, not same. So in conclusion, I think we can now say we've got a case dealing with the interpretation of the phrase similar finance charges in the context of Section 24J. It is only a tax court case, and I think it might well go on appeal. So if you are affected by this or your clients are affected, I think it is a space to watch out for some developments. That's it for today's episode. If you've got any questions, comments, ideas for future episodes, please send me an email. My email address is in the show notes. If you like the podcast, please go and subscribe for the podcast on your favorite platform. And of course, tell all your friends and colleagues about it. Just as always, the podcast is not intended to be tax advice. It's for information purposes only. Until next time, goodbye.